Okay, good afternoon, everybody. It's about 1 o'clock p.m. I'm full of hearing examiner for the city of Lacey. We are holding a public hearing today to consider a variance application. It's for the project titled Shady Lane ADU, project number 23-0316. And apologize for whatever reason my video isn't working today, so I'll be kind of the Wizard of Oz talking from above at you, but that shouldn't prove to be too much of an impediment to what we're trying to accomplish today. The hearing format is to start off with a presentation from staff. I believe that'll be Mr. Font, who will give us an overview of the project and what the request is. Once he's done making his presentation, we'll move on to applicant comments. And after that, we'll move on to public comments, and that anyone who's participating today will have an opportunity to speak. We'll explain how you can participate once we get to that portion of the hearing. So don't worry, we'll make sure that you'll be heard. After that, we move back to Mr. Font to answer any questions that were raised, and he also has an opportunity to provide any information he thinks is necessary to complete the record. Then the applicant gets final word, and I get 10 business days to issue a final decision. Now, by state law, I'm only allowed to consider evidence that's put into the record, and Mr. Font has put together a staff report that includes several exhibits that he wants to be put into the record. And let me see if I got that exhibit list. Mr. Font, do you have a copy of the exhibit list you can share screen with at this point?
Yeah, I can pull it up. Give me just one moment here.
Why don't we put that up on the screen? So I'm just going to ask if anyone has any objections or needs to see any of the documents that he has listed on the exhibit list. By state law, I'm only allowed to consider those documents and the testimony that's put in the record today. I'm not allowed to talk to staff about the hearing outside of the hearing itself. I have no knowledge of the projects except for so far the staff report and the exhibits that Mr. Font has put together. So see what he's got to put up there. And I do realize too that the applicant's counsel has also submitted an additional exhibit, and I have read that and looked at the case law as well. So I'm briefed on those issues as well.
There we go.
Right now, Mr. Font has 9 documents that he wants to be put in the record. It includes his staff report, the land use application, the variance permit application. There's some letter of support involved, environmental checklist, the site plan, notices and decisions, and some assessor data. So at that point, we're also going to add an exhibit 10 to the list, which is the letter from applicant's counsel dated May 24th, 2024 from, let's see, who's the attorney that wrote that one. That was from Ms. Heather Burgess. So at this point, I just want to ask if there are any objections or any need to see any of the documents of exhibits 1 through 10, exhibits 1 through 9 being listed in the virtual hearing, and exhibit 10 being the Heather Burgess letter. Any objections or anyone need to see them? Okay, seeing none, we'll go ahead then at exhibits 1 through 10. Mr. Font, let me swear you in. Just raise your right hand. Do you swear affirm to tell the truth, nothing but the truth in this proceeding?
I do.
Go ahead.
On that note for exhibits, Mr. Examiner, is it possible to submit a 11th exhibit? It's just a PowerPoint presentation kind of summarizing the staff report with some images primarily taken.
The parties are, of course, free to present exhibits anytime before the hearing is closed today when it's their turn to speak. So any objections over staff PowerPoint at this point being put into the record? Okay, hearing seeing none, we'll admit that as well as exhibit 11. Okay, go ahead, Mr. Font.
Okay, let me get that prepped up.
Again, at this point, I can't remember if I did. Did we get that done?
What was that?
Did I swear you in? I think I did.
You did, yes. Yes.
Okay, go ahead.
All right, let me get this roller. Okay, is the oh, looks like it might not be the right slide. Is the presentation coming through for you guys? Is this the right screen? Perfect. Okay. So, good afternoon, everyone. My name's Reese Fant. I'm an associate planner here at the City of Lacey. I have put together the staff report for the variance that we are looking through today. The project aim and background, just for a little oversight. The property owner and applicant has applied for a variance to their residential lot at 6417 Shady Lane. The property is a narrow lakefront parcel, is split zoned, low density residential and shoreline residential. It contains an easement for the applicant, the neighbor, for a drive aisle access. The applicant would like to construct an accessory structure for the purpose of a potential shop, for a shop and a potential ADU or loft. Though that is down the road and not the subject of approval today itself. However, due to the built-out nature of the lot in conjunction with the access easement and downward slope of Hicks Lake, the applicant contests that there is no place to erect the structure, and they seek to build. The applicant is seeking thus to reduce the front yard setback of the property, which is traditionally 16 feet from the property line that abuts the fronting right-of-way, to 5 feet. Following Lacey Municipal Code 1690, the hearing examiner may grant a variance according to the quasi-judicial process if all elements of 1690-005 are met. 1690-005, these are the main subsections of that section of code in which to review to see if a variance can be granted. Starting with a special privilege, special unique characteristics or special or unique circumstance, public welfare, and cause of condition. Starting with LMC section 1690-05A, the language states, a variance will not constitute a grant of special privilege inconsistent with the limitation upon uses of other properties in the vicinity and zone that the property on behalf of which the applicant has filed is located. So the applicant contends that a reduction in the front yard setback of the lot from the standard 16 feet front yard to 5 feet would not grant a special privilege, as there are at least 6 other properties around Hicks Lake that have similarly sized detached structures within that 16-foot front property line in the low density residential district. These examples can be found in Exhibit 3. In short, staff has found that the 6 example properties that the applicant provided were all constructed before the city of Lacey was incorporated in 1966, and thus were developed outside of the current city's development code. It would not be permitted with a current city code. Staff finds that because there were no examples demonstrating that the structures have been permitted within the 16 feet setback under current zoning standards or through the variance process on Shady Lane, staff finds that the intrusion into the front yard setback of the use for an accessory structure would in fact grant a special privilege. Subsection B of 1690-005, the language states that such variance is necessary because special circumstances relating to the size, shape, topography, location, or surrounding of the subject property to provide it with use rights and privileges permitted to other properties in the vicinity and in the zone in which the subject property is located. The applicant contends that the physical space between the driveway easement and the front property line and the area between the driveway easement and the existing structure on site leave a reduced amount of buildable land that does not provide adequate maneuvering room to safely park a car in the garage. Additionally, given the narrowness of the lot, a detached garage waterward of the existing house is not feasible because there's no way to access that portion of the property with a personal vehicle. Staff does concur that the easement would be a special circumstance in conjunction with the narrow nature of the lot. Staff also concurs it would be infeasible to construct a detached accessory structure for the purposes of a private passenger vehicle, waterward of the primary structure of the property due to the slope and zoning restrictions. It should be noted that the applicant does currently have a 2-car garage for vehicle storage, however. And then this is just a image from Google Maps showing the property from the street view. Subsection C, public welfare. The language states that the granting of such a variance will not be materially detrimental to the public welfare or injurious to the property or improvements to which the subject property is situated. Staff does concur that a reduction in the front yard setback from 16 feet to 5 feet with the intent to construct an accessory structure would not materially detrimental to the public welfare or injurious to the property or improvements to the vicinity and zone on which the property is situated. And finally, cause of condition, subsection D of 1690-005. The special conditions and circumstances do not result from the actions of the applicant. Upon reviewing the easement documents attached to Exhibit 3, staff found that it appears the driveway easement was created by the applicant and recorded on 6/20/2023 at Thurston County, Washington. The grantors and grantees being Camilla James and the applicant, and Stan Borgo, the neighbor to which the easement is shared. Staff does find, however, that the narrow nature of the lot and shoreline constraints do not result from the actions of the applicant. Pursuant to city code, the city would be amenable to a single shared access point between the two properties or other alternatives. City code does not require the applicant to have the easement in its current form. Staff conclusion and recommendation: the city recommends the denial of the variance permit. The requirements of 1690-005A were not met, as there were no examples of a structure permitted within the 16-foot setback in the current zoning standards or through the variance process on Shady Lane. The intrusion to the front yard setback for use of an accessory structure would grant a special privilege. Additionally, 1690-005D was not met because the driveway easement appears to have been created by the applicant and recorded on 6/20/2023 by Thurston County, Washington. It also does not seem that all alternatives. It also seems that not all alternatives were explored, such as changing the location of access or the easement. And then additional resources and tools for the examiner would be Google Maps, Thurston County Assessor Property Search, which was used in some of the for exhibit number 7, and then Thurston County Geodata, which I believe was used by the applicant as well in their assessment of some of the sites and setbacks. That is the summary of the site and our analysis. And with that, I can kick it back to you, Mr. Olbrichs.
Okay, yeah, just a few questions, Mr. Pratt. I guess big one for me, when I think about the special privileges and limitations on use, I think I'm thinking about, are they able to develop their property in a fashion that's similar to other properties in the area? And that's not about how close you are to the setback, but about the development potential of the lot. I mean, are there other, and so the way I look at that standard is, do other lots in the area also have shops, second accessory structures like that? Do most lots have shops? You see that in rural areas a lot, and then you consider that to be you wouldn't consider it to be a special privilege to enable, the applicant to build a shop. In a more urbanized area like Lacey, shops aren't that common actually, but maybe they are. So I'm kind of curious, in around this specific area, do a lot of the lots have shops, or in Lacey in general, do people tend to have shops on their lots?
It's a fairly common occurrence for a site to have a lot, and that was one of the intents of including Google Maps and the Thurston County Geodata, so that if you did wish to look at any other sites within Lacey, those resources would be available to you. But yes, it is not a uncommon occurrence.
Okay. And in terms of just house size, is the size of the home size of the applicant pretty comparable to other sizes? Is it, is it a lot smaller or bigger, or, where does it fall in that range?
I would say it's standard or larger. I can't off the top of my head recall the exact square footage. So I could leave that to the applicant
Okay, okay.
to compare.
And so I take it staff's position has not changed in light of Exhibit 11 or excuse me, I guess Exhibit 10 actually. That's what I'm talking about. Yeah.
No, we did have a little bit of time to review that here today, and staff's position has not changed on that.
Okay.
We looked at the language from subsection A. Let's see here. Let me find that. Perfect. So variance will not constitute a grant of special privilege inconsistent with the limitation upon uses of other properties in the vicinity of your zone. So there's that specific language with the limitation upon uses. We have interpreted or applied that as not so much, the use per se, like is it commercial or residential in that sense, because that would be, a zoning change if someone were to go through that process, but how the site is used. So if somebody wanted to build a shop on their lot and within that 16 feet, is that granting a special privilege for them to do within 16 as opposed to the standard setback?
Okay. Okay. Sounds good. Yeah, it's useful to have the staff position on that. And I will mention this, I think mainly mostly for the applicant's counsel to address, but I mean, there's old case law from 1978 basically that provides for the special circumstances element. You can't consider non-conforming uses as a comparison, because if you did, that would kind of undercut the council's intent to have amended its code. I mean, if they're trying to get if the council's trying to increase setback requirements in its zoning code, it doesn't help very much if the variances are granted on the basis that prior development has been allowed to build closer, and so the courts aren't willing to look at non-conforming uses in a general sense, at least by that 1978 case. That was Ling versus Whatcom County. But there is a case from 85, Sherwood versus Grant County, that essentially provided just the opposite. They found for a use variance that somebody was asking for a mobile home in an area where that wasn't allowed, but since there were mobile homes all around it, and for that reason, even though they were non-conforming, they said that was a special circumstance. And the only way I've been able to reconcile those two cases is that I think if you have special circumstances that are localized to a particular site where the variance applicant is seeking the variance, if it's unique to that particular vicinity, then you can look at those non-conforming uses. But if it's something that's spread throughout the zoning district that imposes the new standard, then you can. So anyway, like I said, Mr. Fan, mainly for applicants' counsel to address if they find that pertinent, but that is case law that I'll be looking at to resolve this issue. So anyway, with that, let's move on to the applicant. And who's going to be speaking on behalf of the applicant today?
Mr. Albrecht, I'll start out, and then we'd like to ask that the applicant say a few words about her residence, and then Ms. Burgess may jump in with a few extra items.
Okay, and are you Mr. Penrose? Is that correct?
Yeah, that's correct.
Okay, let me swear in. Mr. Penrose, do you swear affirm to tell the truth, nothing but the truth in this proceeding?
I do.
Okay, great. Go ahead.
All right. Well, thank you, and thank you, staff, for preparing the report and for the presentation this afternoon. I'm not going to reiterate all of the details that are within our within the application. We still feel confident that the items that are contained in the applicant's report do meet the standard for the four-part standard for the variance. And obviously we are quite familiar with Thurston Geodata and the other pieces in kind of preparing for this hearing. In that regard, I looked at all the properties around Hicks Lake, which are all zoned low density and then have that shoreline designation on it as well. There's about 128 properties around Hicks Lake that are residentially owned. I was only able to find 10 that did not have some type of outbuilding or outstructure somewhere on the property. So it's very, very common to have a detached out structure somewhere around the lake. And I'm not even counting like boathouses and things that are waterward. I'm talking about things that are off of Hicks or Carpenter or some other access point. one of the interesting things about waterfront properties is there's always kind of a question about where's the front and where's the rear. I know it doesn't meet quite the normal standard of, front yards are where the property is accessed off of, because predominantly these houses are oriented towards the lake. And so Ms. James' property in particular is very narrow. It's one of the most narrow lots on Hicks Lake. And they've used it as best they can, but as she will speak to, they're just very, very constrained with their space. Their home is actually quite small compared to regular homes on the lake, and actually probably throughout Lacey in general. And so they are trying to find a way to balance some of the storage issues that they're having. So I think that's an important factor, and I believe, when establishing these uses and seeking a spot to place this shop, the applicant chose to locate that as far away from the shoreline as possible. We often have to make choices as planners and homeowners in the development realm where the priorities are, and they've chosen to try to move it as far away as possible from the shoreline in order to keep that strong environmental ethos going, and make sure the lake is the groundwater and the surface water runoff is all protected. So that was a judgment that they made, and then finally, the property is it is located a bit farther off Shady Lane than you might expect. I don't know if the examiner had a chance to visit the site yet, but the fog line is about 6 feet from the so the edge of the traveled way is about 6 feet from the fence, and the fence is about 6 feet from the proposed shop. So there already is a pretty significant, or would be a pretty significant setback from the travel way. And that's really part of the point for setbacks anyways, right? It's to provide clear access and clear sight lines for people who are traveling, as well as, privacy for those owners. So this particular proposal for the location of the shop kind of has to balance a lot of those things: the site, the small property size, the location on Hicks Lake, the shoreline, the setbacks, the travel way there of Shady Lane, and then this access easement that exists between the two property owners. So those are the few other items that I just wanted to raise for you. But if I might, I'd like to turn it over to Ms. James to kind of comment on why she's asking for this variance.
Okay, well, Mr. Tremors, before we do, I just want one clarification question for you. You mentioned there are only 10 lots that don't have outbuildings. Is that 10 lots along Lake Hicks, I take it?
Yes, sir.
Okay, and how many lots are there total about,
I counted about 1/28, and there's a little bit of a, some of these properties have like a pipe stem connection all the way to the lake. So they've got, lake access, but their house is set significantly back, and there's 2 or 3 homes in the front. So some of those I didn't count the same. So it's a rough number. I'd say, order of magnitude is pretty close. I feel pretty good and confident about that, but that's a substantial number, less than 10% of them that don't have an outbuilding, and you can pull that information as well from the assessor's record and see if there's a recorded permitted structures on that. And I venture to say over 90% have detached structures on those sites.
Okay, and how did you collect your data? Was that from the assessor's records yourself?
Yes, both the geodata's got a building layers, so you can see that, but that's as staff knows and the county knows as well as you probably do, that not all structures are indicated on that building layer. So it's really an aerial photo kind of building layer combination, and then just trying to match those up with what the assessor says has been recorded as a building permit on the site.
Okay, great. All right. Thanks, Mr. Penrose. All right, Ms. James, let me swear you in then. So raise your right hand. Do you swear or affirm to tell the truth, nothing but the truth in this proceeding?
I do.
Okay, great. Go ahead.
So my house is actually really small. It is a 2-bedroom house. It does not even have a laundry room in it. So I had to put a laundry room out in my very small 2-car garage. So one half of the garage I park my car in, the other half is a laundry room. But we cannot fit a truck in it. It's too small for a truck. My car barely fits in it as it is. I have been stolen from 3 times in the last 2 years. The first time they cleaned out the back of the truck. They took a $5,000 pressure washer out of the back of it, a backpack blower, some other yard equipment. I called the police. The police said that I just had to submit it to my insurance company. They gave me a report number, but that was it. They said they were not pursuing property loss. So we bought one of those like heavy duty diamond plated toolboxes for the back of the truck that locks so that we could keep everything in that. They literally came in a couple months later and pried that toolbox out of the back of the truck and took probably $10,000 in tools out of the back of the truck. So we bought a tonneau cover that locks, a very expensive tonneau cover. A couple months later, they came, they pried that open, damaged the truck, and cleaned out the back of his truck again. I have got to have a place to park this truck. It's just becoming such an issue. I have had on my camera, and I have them all saved to my phone, several times where somebody has come into my yard at night, and now that we are not keeping anything in the truck, and they're trying to open the doors, they're trying to get in the back of the truck. I mean, it's constant. Shady Lane can be accessed from Ruddle and Carpenter, 2 main roads. So it's really easy for them to come in, clean us out, and hit the road. And Stan next door to me, we had somebody pull in, hook up his trailer, take his trailer out the road, go out the other direction. So it's become a huge issue for us here. And if I was to put this closer, so Stan and I have this shared driveway. We're right on that sharp corner on Shady Lane. And one of us, we go in one side and out the other side because it's the safest way to do that. But there would be no way, if we eliminated that shared driveway, there'd be no way to get our trailers in and out, our boats in and out. Backing onto Shady Lane, I'd have to have somebody go stand on the road and wave me out. It would just be too dangerous to try to back onto Shady Lane. As far as that easement goes, so when I purchased this property, I was told that we had a recorded easement for that shared driveway. And it was when I went into this process to try to get a permit and we had the county search for it, they couldn't find it. So Stan and I talked and we both agreed that we needed to formalize that because if that was ever eliminated for either one of us, it would make our property unusable as far as getting our things in and out of that driveway. So that's why we formalized that. And Stan and I have a very, very good relationship, but I can tell you that if I attempted to do that, he would take me to court. I mean, we've been using that for, I don't know how many years, 17 years now, I guess. So it would be impossible for me to eliminate that for either one of us, actually. So I have lived on this lake for 50 years. I grew up on the other side of the lake. My parents bought a piece of property at the other end of the lake when I was younger, and my dad still lives down there. My mom lives across the street. I mean, I do not want to sell my home. I want to stay here. I help both of my parents. I love living on this lake, but it's becoming a situation where I don't have a place to store anything. Like I said, I have a 2-bedroom home. I can't put my outdoor furniture anywhere, and I am sick and tired of getting stolen from in my own driveway.
Thank you, Ms. James, for comments. All right, anyone else on the applicant team? Mr. Penrose, were you going to have Ms. Burgess say anything, or?
If she wishes, yes.
Thanks, Mr. Albrecht. Can you hear me okay?
Yeah, go ahead.
I mean, I think I laid out the applicant's argument on this point fairly clearly in the written correspondence. But just to respond to the case law that you brought up, which I'm familiar with, I think part of the issue is if you look closely, and I cited this in the materials, if you look at the supplemental application that the city prepares, it only includes a portion of the criteria from subsection 8 in it, and it doesn't mention use. So in providing the examples, which, assuming they were actually constructed prior to 1966, were legally non-conforming as to the city's codes, that's fine. But prompted with a different question, as Mr. Penrose did here today, could have easily provided other information about, the number of shops that are on the lake or other information. So the information that was given is kind of directly in response to the city's application prompt. And if you look at the language in the city's code, it's identical to the language in the city of Bellevue's code in the Hoburg case that we cited for you in the materials. It's that criterion, also criterion A asked about if the variance would not constitute a grant of special privilege inconsistent with the limitation upon uses of other properties in the vicinity. The Court of Appeals went on to say that criterion A, that criterion, restricts the granting of use variances. So what's proposed here is, as you know, is an area variance. It's not a use variance. We're not seeking to do anything inconsistent with the uses that are on the lake, simply to have a structure so that the applicant can secure her belongings and use her property in a manner consistent with all the other homeowners on the lake. And I would just simply think that the city staff is mistaken in applying that particular criterion, which we believe under the case law is intended to, restrict use variances. Otherwise, somebody would have to get a variance first on the street in order for anybody else to get a variance. And if you applied the code the way the city is presenting it, the first person can never get a variance because no other variance had been granted. So at that point, it becomes circular and doesn't afford the bulk and dimensional relief that type of code is intended to provide. And then the second criteria issue has to do with the easement. As we indicated in the materials and as Ms. James testified, this was an easement that, although she believed was recorded, was still legally established through prescription. And all that the recorded instrument did was document and fix that location to avoid any dispute in the future. But as cited in the case law in our materials, that prescriptive right was conferred at the time the prescriptive period passed, and so couldn't be disturbed or altered. So all that was doing is perfecting it and cleaning up the record from the applicant's perspective. So from a legal standpoint, we believe that the city's simply misapplied its code. Appreciate the time and effort and analysis gone into the application, but that the recommendation of denial is misplaced and that the examiner can make the findings necessary to support approval. And that's all I had to offer in addition to what we've previously submitted, subject to your questions. Mr. Olbrecht, thank you.
Thanks, Ms. Burgess. No more questions. I think pretty straightforward at this point. Well, let's move on to public comment at this point. And Mr. Fant, do you see any members of the public who want to say something at this point?
I don't believe we have anybody online on the attendees, and I have Sarah Bartz in the council chambers. And Sarah, it looks like it's just you, correct?
Correct.
All right.
Okay, Ms. Bartz, let me swear you in. Just raise your right hand. Do you swear affirm to tell the truth, nothing but the truth in this proceeding? Oh, you're not. Okay.
I'm not testifying.
Okay, all right, sounds good. And then for those who are participating virtually, if you want to say something, just click on the virtual raise hand button at the bottom of your screen if you want to say something. It looks like we've got no takers. And Mr. Pratt, like you said, it doesn't look like there's anyone participating who's not involved in this case, right? No members of the public, in other words.
Correct.
Okay, all right. All right, well, let's take it back to you then. Did you have any final comments you wanted to make or responses?
I do not, but it looks like Samara Seymour, one of our senior planners, does have her hand raised.
Okay, Ms. Seymour, let me swear you in. Just raise your right hand and you want to unmute yourself too. There you go. You swear affirm to tell the truth, nothing but the truth in this proceeding?
I do, yes.
Okay, great. Go ahead.
I really don't have too much to add. I think Reese did a pretty good job. I just wanted to, and I will obviously defer to you and Ms. Burgess on, the existing case law. So I'm not necessarily, the intent of my testimony isn't to contradict that or whatever. I just wanted to provide additional clarity on staff's interpretation of this particular section of our code in terms of how we have used that in the past. So that first section, section A of 1690-005 that talks about inconsistent with limitation upon uses of other properties, as Ms. Burgess noted, is not necessarily, the staff's interpretation in the past has not been that strictly say how the use of a property in terms of like a zoning use, an allowed use, or a permitted use. Those are the types of things that are dictated by our zoning code. So the use in that, the way that, again, in the past, staff at the city of Lacey has interpreted that is how, how the limitations on how any particular use is used. So in this case, how the accessory structure is used on the site, how it's cited on the site. Because further down in that chapter, we do provide 1690-020 does provide options that applicants in the city can use to modify front and rear yard setbacks. And so the intent of that section addresses how the city looks at varying those setbacks. So I just wanted to clarify, like I said, I'm not necessarily in an attempt to take away from the case law that has already been cited, but just to provide further context for city's interpretation of that code.
Okay, thanks, Ms. Seymour. Appreciate that input. All right, well, I guess applicant gets final word at this point. If they want to say anything, now's your chance, Mr. Penrose.
I have nothing further, Ms. James.
Okay, yeah, I think we've covered everything pretty exhaustively at this point, so I'll go ahead and close the hearing. And yeah, this is I'm a little bit of a legal walk. This is a chance I get to really take a deep dive into those variance court opinions and figure out how to address this particular issue. Like I said, I in the past have considered special privilege kind of at a more fundamental level, as if everyone gets to build a reasonably sized home in the surrounding vicinity, then this person should too, kind of thing. Or if everyone gets an accessory structure, this person should too, if it meets all the variance criteria. But I think in particular, Ms. Seymour's comments and things are really good food for thought. So I'll take a look at the case law in light of that and look at both positions, of course, and I'll put together a pretty detailed decision as to which way I go. I think this one, it could go either way. And so it's something I really need to look at closely from a legal perspective and look forward to doing that. So we'll get my decision in 10 business days as required. That's a couple weeks from now. And that'll be, of course, emailed to the applicants and I'll email staff and then they'll distribute it to the applicants and that kind of thing. And I believe in Lacey, that's appealable to Superior Court. So anyway, with all that, we got a raised hand from Ms. Burgess. Okay.
Yeah, Mr. Olbrecht, if you don't mind, Ms. Seymour's closing, kind of comments there mentioned an ability for staff to afford relief, to a setback variance, and I think it's covered in the staff report, but that wasn't a specific element that we talked about, I don't think. Wanted to make sure that before you close the record on that issue, given the issues here, that either that Mr. Penrose could make sure was clear for the record that was or was not adequate to get the garage in here that's proposed. I think that answer should be clear, but I want to make sure that there isn't any question for you as you review the record.
Oh, okay. So you're saying, Mr. Penrose, and you want him to add some comment at this point? Is that?
Yeah, about the ability to fit the garage in using the administrative reduction to the setback under the city's code. Thanks.
Okay, Mr. Penrose, you could clarify that a little bit.
Yeah, and I'll do that. And then I don't mean to pass it along, but Ms. James, that it might end up on with you as well, because the proposed shop, the size of the proposed shop is as you can see in the site plans and Mr. Olbrecht, if you go by the property and do a drive-by, you'll just see how tight it is. You can also see that in the aerial photos. There really is nowhere else to put this structure without building it right on top of that driveway easement, or having it substantially shrunk to the point where it's no longer usable for the uses that Ms. James is seeking. So it's a very tight envelope, and the site plan that's on, I believe, page 3 of our supplemental materials can kind of indicate just how tight that it was. We did work with the applicant and the applicant's architect and builder to get that to a point where it met all the impervious surface standards, as that was an important one as well, because it's a shoreline lot. So all of those other pieces were met. The setback variance was the one that was just too tight to do without without that variance request.
Okay, all right. Ms. James, did you want to add anything to that?
No, if I had to reduce the size of the building, we wouldn't be able to get the truck in there. So that's the big issue for us.
Okay, okay, got it. Okay, thank you. All right, yeah, that's good information to have to complete the record. So I think with that, then we are adjourned. So thank you all for participating. Like I said, I'll get that decision out in a couple of weeks. So have a good day.
Thank you.
Thanks,
Thank
everyone.
you.